Okay, so students, we are going to discuss about Indian legal system. First, we will discuss about the setup of executive in the legislature. So, India, as it is mentioned in our preamble, is a republic. That means that we are having a written constitution which expressly declares that we are going to have a elected head of the state. Head of state in India is the President of India, and President of India is elected indirectly by people of India. I am saying indirectly because President of India is elected by the Union Parliament plus the members of the state legislature. So that simply means that every person who is a citizen of India and otherwise is not disqualified to contest the elections of President of India, he has an equal chance of becoming head of state. Now this is in a contradiction to that of those states which are having monarchical systems. For example, UK. UK is still having a king or a monarch as head of its state. Alright, right now it's the King Charles who is head of the state in UK. He is not elected. He has gained that position because of his royal legacy. But so far as India is concerned, every 5 years, generally presidential elections are conducted, and accordingly we have a new president of India after every 5 years. Now, so far as executive is concerned, over here we will find that there is a division of power at 3 levels. To govern the country as a whole, we are having a union government headed by the Prime Minister and his Council of Ministers. India is divided into various states and union territories. For example, Punjab, Haryana, UP, Jammu and Kashmir, Himachal, Tamil Nadu, Kerala, Maharashtra, Andhra Pradesh, Madhya Pradesh, Rajasthan. These are a few states of India. Puducherry, Chandigarh, Daman and Diu, these are examples of union territories. So we are having a country which is divided into various states and UTs. Now in every state you will find there is a state government which is governing that particular state. The head of the state is the governor, plus each of the state government is having a chief minister plus a council of ministers. Then every state in our country is divided into various districts. Each district is having various cities, plus there are also a lot of villages. So far as cities are concerned, they are governed by a third layer of governance that is called the municipal corporations or the municipal councils. So they are basically governing at the local level, addressing the local issues of a city. Then for villages, we are having village councils or panchayats who are responsible for governance of a village. So this is the system of 3-tier governance that we have introduced, which is running in our country. Central level, union government, government of India. Then we have state governments, that is in every state there is a chief minister and council of ministers. Government of Punjab, government of Maharashtra, government of Haryana, government of Delhi. Then we have government of Uttar Pradesh, government of Bihar, government of Assam, government of Manipur, government of Andhra Pradesh, government of Kerala. Then so far as law-making organs of the state are concerned, we are having central legislature for the country as a whole called as the Parliament of India. In every state there is a state legislature. Alright. For governance, as I told you, at the union level we are having Union Government of India. In every state we are having a state government. So far as judiciary is concerned, judiciary is completely integrated. We have at the top Supreme Court of India, which is the apex court, and whose decisions are binding on all courts which are subordinate to it. For almost every state we are having a high court. Some states are sharing the high courts. For example, the High Court of Punjab and Haryana, it is basically serving the state of Haryana, state of Punjab, and the Union Territory of Chandigarh. So many states are having single High Court, while many are sharing the High Courts. Then below the High Courts, for each district in every state, there is a district court. So far as our structure of government is concerned, we are following the parliamentary system of governance that we have derived from our colonial legacy. We have adopted the British model of governance, parliamentary system of governance. Now in this system, there is a amalgamation of power between the legislature and the executive. I'll explain it in a simplified manner. The Parliament of India, that is the Union Legislature, is having two houses. It is a bicameral legislature. It is having two houses. One is Council of States, another is the House of People, alright, which is called as Lok Sabha. So far as Council of States is concerned, the members of Council of State, they are elected by the members of the state legislative assemblies. Alright, every state is having a legislative assembly. So from every state, a fixed number of members are being sent to the Council of States in the Parliament. Alright, but so far as House of People is concerned, the members of House of People are directly elected by the people of India through a general election, and that general election is usually conducted every 5 years. Now, every 5 years, the people vote to elect the representatives from their constituency. Once elected, now these representatives who become member of House of People, they are called as members of Parliament. So therefore, whether if a representative is a part of Council of States or a House of People, that member of the representative is called as member of Parliament. Now, it is from the House of People generally you will find that whoever secures a majority support in House of People, he becomes the Prime Minister of the country. So basically, the executive government, that is Government of India, it is being established every 5 years from among the persons who are member of the Union Legislature, that is the Parliament. That is why we call it a parliamentary system of government. That is the persons who are going to govern the country as from the top offices of the executive and are going to hold the top offices of the executive. Those persons are going to be the members of the Parliament simultaneously. Alright. So the Union government, it comprises of President of India, the Prime Minister and his Council of Ministers. The Prime Minister and his Council of Ministers, they form Government of India, and they are, as I told you, members of the Parliament. The Indian Parliament, as I told you, it is bicameral, having two houses, House of People and Council of States. Furthermore, the members of House of People, as I told you, are directly elected by the people of India via general elections. How? I told you. There is an Election Commission of India, which every 5 years is going to conduct elections for election of representatives to House of People. Similarly, Election Commission of India is also going to conduct elections for the representatives to the Rajya Sabha, but this election, as I told you, is indirect. Then Election Commission is also going to conduct elections for election of President of India as well. So President is the head of the government, and the real power although lies with that of Prime Minister and Council of Ministers, because by and large the President is supposed to act on the basis of the advice which is tendered by Prime Minister and his Council of Ministers, and President is bound by the advice which is given by Prime Minister and his Council of Ministers. So therefore it is the Council of Ministers who largely control the acts of the President, although all the acts of the Government of India are done in the name of President of India. Now, members of the legislature, they are running the executive, and at the same time, since they are running the government, so simultaneously they are also responsible to the Parliament for their actions. In the Parliament, they can be questioned, they can be made accountable for their decisions that they make as Prime Minister or as Council of Ministers. Okay. Now coming to the Indian judiciary, we are having an integrated system of judiciary. That is, we have a single Supreme Court of India for the country. Every state is having usually a High Court for itself with certain exceptions. And the country as a whole is divided into states. Each state is divided into various districts, and every district is having its own district court. So at the top is the Supreme Court of India. Now this court, in the hierarchy of courts, is the highest court of India. It is located at New Delhi, and there are in total 33 judges appointed to the Supreme Court of India. In total 32 justices plus one Chief Justice of India. All the judges of Supreme Court of India are appointed by the President of India in consultation with the names which are forwarded by the Judicial Collegium. That is, there is collegium system in India wherein the judges advise on the recommendations which are given for appointment to the office of a judge to High Court or Supreme Court. Now all courts of India which are subordinate to Supreme Court of India, they are bound to follow the decisions of Supreme Court. They cannot give a decision which is contrary to that of the judgments of Supreme Court. Now Supreme Court can hear, number one, certain category of cases which can be filed directly to the Supreme Court. Certain other category of cases which are going to come in form of an appeal against the decisions of the courts which are subordinate to Supreme Court. So far as those cases are concerned which can be heard directly by the Supreme Court, they include, number one, the cases where there is a dispute between the union and the state, or between two or more states, or between union plus a state or two or more states, plus state or two or more states. Plus, in case somebody's fundamental rights are violated, they can also move directly to the Supreme Court under Article 32 of the Constitution using the writ jurisdiction of the Supreme Court. Secondly, Supreme Court is also hearing appeals from High Courts. So, all the cases, whether it be constitutional cases, civil cases, criminal cases, which have been decided by the High Court, in all those cases, against the decisions of the High Court, against the judgments of the High Courts, final appeal can be made to the Supreme Court. Supreme Court is also advising the President of India when a reference is made by the Office of President of India on a question of law or a question of public importance. However, the President of India is not bound by the advice which is tendered by the Supreme Court. Then we have the High Courts. India administratively, as I told you, is divided into various states, and each state usually is having its own high court. However, there are certain high courts which are serving more than one state. For example, state of Punjab, state of Haryana, and UT of Chandigarh, they have a single high court located at Chandigarh. Each high court is having a chief justice plus n number of judges which are appointed to that high court. There is no limit to the number of judges which can be appointed in a high court. The judges of the high court are also appointed by President of India in consultation with the Chief Justice of India, the governor of that particular state, plus the Chief Justice of that high court. Usually the location of a high court is the capital city of the state. For example, the capital of Punjab and Haryana is Chandigarh. The capital of Punjab and Haryana is Chandigarh. So you will find that the High Court of Punjab and Haryana is located at Chandigarh. Okay. So far as hierarchy is concerned, High Court is subordinate to Supreme Court, and it is bound by the decisions made by the Supreme Court. Against the decisions of the High Court, appeals can be made to the Supreme Court. Supreme Court, when the matter comes in appeal, can either confirm the decision of the High Court, or it can also alter the decision of the High Court. It can also change the decision of the High Court. High Court also has got the power to issue writs under Article 226, 227. High Court is empowered to decide civil appeals which are coming to it from district courts, criminal appeals which are coming to it from district courts, plus it can also hear petitions which are being filed directly to High Court. The High Court of a state is empowered to supervise the working of all the subordinate district courts in its territory. The High Court is supposed to act as an interpreter of the Constitution and the laws, and it has also got the power to issue writs for protecting fundamental rights of people. Now moving ahead, every state is divided into various districts, and for each district generally there is one district court. You will find that most of the cases are initiated at the district level. They are initially filed at the district level. District courts are basically serving justice at the grassroots level. So far as structure of a district court is concerned, a district court is having number 1 civil courts, number 2 criminal courts, number 3 revenue courts. So every district court is having three subcategory of courts. I repeat again, every district court is having three subcategories of courts. First is civil court, second is criminal court, and third is revenue court. The senior most judge of the district is the district judge. Let us first understand the structure of district civil courts. So in civil courts, the senior most judge is the district judge. Then next to him is civil judge senior division. He is empowered to decide cases which involve a high monetary value. Next to civil judge senior division is civil judge junior division. Now he is going to hear the cases of pecuniary value, monetary value, which is relatively lower than that of civil judge senior division. So this is the hierarchy of the civil courts in a district. At the top is the court of the district judge, Below him, the Court of Civil Judge Senior Division, that is family courts, because Civil Judge Senior Division is also hearing family courts petitions. Below him, Court of Civil Judge Junior Division, and then below him, Court of Small Causes or Munsif courts, that is those particular cases which are of petty nature. They are heard and decided by the Munsif courts or Court of Small Causes. You will find that certain courts of Civil Judge Senior Division, they are specially dealing with matrimonial and family cases, which may include cases pertaining to divorce, custody of children, maintenance, etc. Coming to criminal courts in a district. Now, in a district, the hierarchy of criminal courts is like this. The highest court in a district which is going to try criminal cases is Court of Sessions Judge. Below him, Court of Additional Sessions Judge. Then below him, Court of Assistant Sessions Judge. These are judges. And below Assistant Session Judge begins the magistracy. Court of Chief Judicial Magistrate, followed by Court of Judicial Magistrate Class 1, and the lowest rung is Court of Judicial Magistrate Class 2. So if we go the other way, lowest rung judicial officer in a district is on the criminal court side, Court of Judicial Magistrate Class 2, then above him Court of Judicial Magistrate Class 1, then above him Court of Chief Judicial Magistrate, then above him Court of Assistant Session Judge, then above him Court of Additional Sessions Judge, and the topmost court in a district is on the side of criminal courts, Court of Sessions Judge. Now, Court of Sessions Judge is presided over by the Session Judge. He is the head of district criminal courts. He has the power to hear and decide the appeals which are coming to him from the magistrate courts, that is from the Court of Judicial Magistrate Class 1, Judicial Magistrate Class 2 and Chief Judicial Magistrate. He is responsible to supervise the functioning of all criminal courts in the district, and he is empowered to give any punishment, including death punishment. In case he gives death punishment to anyone, that death punishment will be confirmed by the High Court of that state. Court of Additional Session Judge, the judicial powers are exactly the same. Session Judge and Additional Session Judge, judicial powers are exactly the same. However, administratively, Session Judge is superior to Additional Session Judge. Court of Assistant Session Judge, he is also hearing serious criminal cases. He is empowered to give maximum punishment of up till 10 years of imprisonment. He cannot award death punishment, he cannot award life imprisonment. Chief Judicial Magistrate, he is head of the magistrate courts. He can give maximum punishment of up till 7 years of imprisonment, and he can also impose unlimited amount of fine. He supervises the functioning of all the judicial magistrates Class 1 and Class 2 in the district court. Court of Judicial Magistrate Class 1, he can award maximum punishment of up till 3 years of imprisonment and a fine of up till 10,000 rupees. Most of the criminal cases are initiated before the Court of Judicial Magistrate Class 1. Now, ranking below Judicial Magistrate Class 1 is Court of Judicial Magistrate Class 2. Basically, he is dealing with petty offences. Maximum punishment that he can award is up till 1 year of imprisonment and fine up till 5,000 rupees. Next to this, the criminal courts is revenue courts. Now, revenue courts are basically dealing with matters of taxation especially in concern of land revenue and allied matters. That is, those revenue matters which are emerging from land and tenancy. What is the structure? At the state level, there is a board of revenue. Then the state is divided into various divisions. State is divided into various divisions. Each division is having a number of districts. For every district, there is a court of financial commissioner or district collector. Below the district collector is the court of subdivisional magistrate, and below him is tehsildar, below him Nayab Tehsildar, and the lowest rank revenue officer is Patwari or Lekpal. So district collector, he is the head of revenue administration of the district. He is going to decide major disputes emerging from land revenue, property partitions, tenancy, etc. And he is responsible to supervise the functioning of all the revenue officers of the district. Below the district magistrate, financial commissioner or district collector is subdivisional magistrate. Every district is divided into subdivisions, and a subdivisional magistrate is charged with the authority to supervise the revenue administration of his subdivision. Below him are various tehsildars. So he is supposed to hear all the appeals which are made against the orders of tehsildar. He deals with disputes related to rent, tenancy, crop sharing, eviction, land possession, etc. Now, at the tehsil level, land records are maintained and land revenue is also collected. Small revenue disputes are decided by the tehsildar. He is the lowest rank decision-making authority on the revenue side. This was all about the judicial system of the country. I am mentioning over here again that we right now are not discussing tribunals. Thank you.